The headline reads as a legal victory, a procedural shield. The highest court has once more intervened, and the papers will not move tonight. That is the surface. That is what people think this is about. Another technical win in a procedural war. But you must listen to the silence that follows the ruling. You must look past the declared victory to the unchanging, unmoving fact at the center of it all. The records themselves, they are not a legal theory. They are numbers on pages. They exist. And for 8 years, across dozens of subpoenas, through state courts and federal courts, through congressional inquiries and criminal investigations, they have never been seen. Not by the public, not by a jury, not by Congress. This is not a story about one blocked subpoena. This is the story of a gravitational field so powerful it bends the most basic machinery of accountability around it. It is a story about how in modern America, the ultimate form of power is not the power to act, but the power to delay, to obscure, to ensure that the clarifying light of a simple fact never reaches the stage where it can be judged. By the time we are finished, you will understand that these records are no longer just financial documents. They have become a metaphysical test of the system itself. You will see this not as a legal battle, but as a live autopsy of institutional velocity. The final unsettling insight is this. The repeated successful blockade of these records proves that for certain kinds of power, the system's immune response, its checks, its balances, its processes can be infected and turned against its own purpose. Once you see the pattern of perpetual deferral, you won't unsee it in every headline to come. Picture a warehouse, not a metaphorical one. A real climate-controlled, secure document storage facility in a nondescript industrial park. Inside, among miles of shelving holding the archived paperwork of corporations and estates, sits a single pallet of bankers' boxes. They are identical to a million others. Their labels are generic. They contain what has been described in various legal filings as the key to understanding a decades-long financial history. A few miles away, in a starkly lit conference room in a federal courthouse, 3 law clerks have just finished reading the same 3-paragraph order from the Supreme Court. The room is silent, save for the hum of the fluorescent lights. They do not celebrate. They do not lament. One of them, the most senior, simply closes the tab on her computer monitor, the light fading from her face. She turns to the other 2. "The stay is extended," she says, her voice flat. "Notify the archivist. The custodial protocol remains in effect. She means the pallet does not move. The locks are not changed. The chain of custody is not transferred. It is a decision that maintains a perfect, pristine stasis. In that sterile room, the law has spoken, and its command is for nothing to happen. The connection between the warehouse and the courthouse is a thread of legal procedure. And tonight, that thread has been gently, definitively placed back in its spool, unused. The scene is not one of conflict, but of maintenance, the maintenance of a void. The fracture is between the promise of process and the reality of perpetual process. The public F-facing argument is always about principle, executive privilege, the sanctity of the office, the overreach of a politically motivated prosecutor. These are the ramparts the defense builds in the media. But behind those ramparts, the strategy is temporal, not philosophical. It is about the calendar, not the Constitution. The goal is not to win the argument on the merits in the court of public opinion. The goal is to ensure the argument about the merits never actually happens in a court of law. Every successful delay, every granted stay is a victory not because it proves innocence, but because it postpones the day innocence or guilt must be proven at all. The allies and spokespeople who hail this as a vindication are engaging in a profound gaslighting. They are celebrating the prevention of a test as if it were the passing of a test. What is being protected is not a legal right, but a state formational ambiguity. What is being insulated is the subject from the conclusive power of a documented fact. What is being avoided is the moment the complex shifting narrative collides with the immutable static truth of a number in a ledger. because narratives can be spun, debated, and doubted. A subpoenaed bank statement once entered into evidence cannot. The fracture, therefore, is in the foundational compact of accountability that when a legitimate authority asks a legitimate question, it receives a legitimate answer within a time frame relevant to the question. That compact has, in this one specific case, shattered. The system is producing rulings on whether to answer, not the answers themselves. We have now left the terrain of political scandal and entered the terrain of docket management and appellate procedure. This is a terrain where public passion is noise, charisma is a weakness. In this terrain, the battle is fought with footnotes, jurisdictional tests, standards of review, and the interpretation of phrases like irreparable harm. This is where instincts honed on a rally stage become liabilities. The institutional machinery here, the Supreme Court's shadow docket, its power to grant stays, is not designed for truth-seeking. It is designed for equilibrium, for maintaining the status quo while the slow wheels of full consideration turn. This is the genius and the horror of the blockade strategy. It transplants the conflict from a terrain where facts matter, a trial, court discovery hearing, to a terrain where only legal risk and procedural balance matter. The court, in granting a stay, is not saying the records are irrelevant or the subpoena is invalid. It is saying, essentially, the legal question of whether this subpoena can be enforced is serious enough that we should not allow enforcement until we are absolutely certain. It is the ultimate institutional caution, and in that caution, a vacuum of accountability is preserved. The ambiguity, the question of what is in the records, does not collapse under the weight of facts. Instead, the process itself becomes a fact, the fact of delay. The institution responds to the clarity of a legal argument for caution, and in doing so perpetuates the opacity surrounding the underlying facts. The terrain has shifted from show us the evidence to let us first litigate for years the meta question of whether you have a right to ask for evidence. Now witness the convergence. First, the legal front. Each successful delay establishes a new procedural precedent, a new hurdle for the next subpoena. It creates a playbook. Challenge, appeal, seek, stay, rinse, repeat. The defense is not arguing one case. It is building a jurisprudence of delay. Second, the political front. The perpetual victory of blockage becomes a self-fulfilling political prophecy. Supporters see a system constantly being beaten, reinforcing the myth of a witch hunt. The very failure of the system to obtain answers is used as proof that the questions were illegitimate. Third, the media front. The story morphs from what is in the records to will the records be released? The scandal becomes procedural, not substantive, a death knell for sustained public attention. Fourth, the psychological front for the opposition. A corrosive exhaustion sets in. It is the fatigue of running toward a receding finish line. The energy required to pursue through labyrinthine legal channels is immense, and with each blockade, the return on that investment of energy diminishes. Donors question the spend. Public attention wanes. This exhaustion is the most dangerous state for any pursuit of accountability because it leads to acceptance. The spectacle-based movement on the other side, however, also shows a fatigue of its own success. The narrative must become louder, the claims of victimhood more grandiose, the attacks on the institutions more vicious because the underlying factual void it protects must be filled with something. And that something is increasingly frantic performance. The subject loses narrative control not by going silent, but by having to scream ever louder to justify why a simple box of papers must remain locked away forever. The fear changes direction. It is no longer the fear of what the boxes contain. It is the quiet institutional fear among some actors of what it means that the system they serve can be so effortlessly, so legally paralyzed. This is not about one man's taxes. This is a pattern that reveals a critical vulnerability in the architecture of accountability. The deeper story is about the weaponization of due process. Due process is the guarantee that power cannot act against you arbitrarily. but what we are observing is its mirror image. The use of every procedural protection not as a shield against arbitrariness, but as an instrument to create arbitrariness to ensure that the ordinary process of asking and answering questions simply cannot occur. The key lesson is that norms erode not only through loud, violent shattering, but through silent, bureaucratic suffocation. A norm is not just a rule against doing something, it is an expectation that something will happen. The expectation that a legitimate legal demand for information will within a reasonable time be satisfied is a norm. That norm is now in critical condition. The final insight the twist teased at the beginning is this. The Supreme Court, in repeatedly blocking the release of these records, may believe it is protecting the integrity of the judicial process from being rushed. But from another angle, it is being used to protect something else entirely from ever being judged. It is being used to sever the final fragile link between political power and factual clarity. The meaning of tonight's headline is that the gravitational field around those boxes remains intact. The system's immune response has been co-opted. The records are not hidden in a vault. They are hidden in plain sight, encased in a perfect, transparent, and legally sanctioned shell of procedure. Pay attention not to the victory laps. Pay attention to the unchanging location of the pallet in the warehouse. Its stationary position is the most eloquent testimony to a new kind of power. The power to keep the lights off forever by convincing everyone it's still daytime somewhere else. Demand clarity. Resist the normalization of the perpetual question mark. For when we accept that some questions are meant only to be litigated, never answered, we have surrendered the very principle that the law exists to discover truth.